Good afternoon. You are live with Courtside with Lawman,
And Carmen B.
and we are here to answer your questions regarding criminal law and the criminal justice system. Please feel free to call in to the podcast. You can reach us at 916 384 8204. Please feel free to call in or to send us questions in the chat.
Yeah, definitely.
Now, we would like to say that our purpose here again is to educate and to inform the public. If you call in and ask a question, it does not establish an attorney client relationship between yourself and myself, Carmen Butler, or lawman, Mr. Staten. But we do want to answer your questions. We know a lot of times people have pending court cases, they have questions, or they have family members that have pending court cases, and they have questions, burning questions, and we want to be able to answer those. You don't have to identify yourself. You can call in anonymously and answer your question. Or, I'm sorry, and ask your question that we will answer.
Or try to answer, for sure. And we like to have lively discussions on things. So topics that you bring up or throw out there and we can comment on them, we will do so. Yes, we don't represent anyone in such
Well,
things.
we do represent some people. We just don't represent people who call in for those questions.
All right.
And the other thing is you can, if you want a confidential attorney-client consultation, you can contact myself, or you can contact Mr. Staten to schedule that at either one of our offices. My office number is 916-443-5288, and Lawman?
916-443-5600.
All right. Now, let's get into it. What
All
do you
right.
have for the public today, Lawman? What's going on?
As we know, the COVID outbreak caused the courts to pretty much shut down for quite a period of time. It definitely forced us to start doing things in a completely different fashion. And right now, what's happening is we're going to try to come back to some courts being opened up for normal business. Since the COVID, most lawyers are appearing via Zoom, and most clients, if they are not there, their appearance are being waived. That's abnormal. So when the courts go back to normal, it'll just be a lot of people in one closed-in room again. So we'll see how that works, but we understand that what's going to happen is some of the criminal courts that are in the jail are going to open up effective April 12th. Department 62 and 60 and the arraignment for night court are going to be conducted at 651I, which is the jail, basically. And they're going to be closed to the general public, the court hearings.
So the general public still will not, prior to the pandemic, if you wanted to come into the courtroom and watch the court proceedings, the general public could do that. You didn't have to have a case on.
Right.
You didn't have to be there for a specific person. Right. You could come into the courtroom and sit and watch. And it's my understanding that
they're going to continue to close that for the public. And what the option was that you can live stream through YouTube the proceedings.
Yes. So the court, actually on the court website, you could search Sacramento County Court live streams, and it would pull up the live streams for all the different courts that were having proceedings. Now, I will note that although initially the courts were kind of closed fully, there have been, for people who are out of custody, appearing in those departments. But what they were doing is bringing individuals in just one or two at a time to have their case called. And that was so that they could maintain the social distancing that is required to try and keep us all safe during this pandemic.
And they did it for lawyers too. The lawyers have to abide by that too, even though one of our natural things is to talk to each other in, close quarters, so to speak. It seems to work. They do a temperature check when you're coming into the court area. They don't do it for the jail itself, but the temperature check when you come to the court area, and they just want to make sure that you're on calendar.
Yes.
So
they were actually doing the temperature check upon entry at the jail, but they stopped doing that. So the sheriff is no longer requiring that. But if you are entering to go to a court appearance down the hallway where the courts are in the Sacramento County Superior courts that are located in the jail building, there is still a sheriff there that is taking your temperature, and that's required by the courts.
correct. So although they're opening up, it seems to be a little bit at a time. It's not fully open, and so the best bet is to check on the live stream if you want to watch the proceedings. It's still hard to get records from the court. I tried to get a couple of orders, and you have to send in a form with pretty much a blank check and explaining that it's no good more than $4 or something like that to get a court order or something from the court files. That's being difficult now because it was so open to the public before that now if you can't go into the courtroom or the jailhouse, you get no records. So
have they opened up that access to not department, but rooms 101 and 102? I do know that room 102 was open because I had a client whose case resolved, and we were actually instructed by the court to go to that room in order to sign the documentation.
Oh.
So I do believe room 102 is open. It may be on a limited basis.
Yeah.
Now, room 101 is where you can go to order court files.
Right.
It is. I'm unsure if room 101 has opened back up.
Right.
Yet.
I don't check the doors, but I don't also see people in there because they're not letting the general public, or at least as of, I guess, yesterday, 2 days ago, they're not letting the general public into the building still. You have to actually have a case in order to be able to come into the building. Now, there may be people out there who are saying, well, you know what? I actually did go into the courtroom for my hearing, so I'm not quite sure what you mean when you say they're opening up. The difference for those departments that Lawman just mentioned is that those departments, the judge is actually now going to be, and his staff is going to be present in the department. So prior to this opening up, if you appeared in that department, the judge was actually on a video screen, and he was not in the building. He was in a different building being video conferenced into the department. So you would be physically in the department, but the judge would not. And so that is the biggest change with this opening of the 3 departments that Lawman just mentioned. That is that the judge and his staff will now be present in the department with the clients as well as the attorneys. And were there some requirements regarding who has to actually appear? Because I know they were going to continue some Zoom appearances on a limited basis. I think you can probably still, I just haven't seen that you can't, but I believe you can still appear. You can still appear by Zoom.
I think if the client is in custody, unless the client has agreed to the attorney appearing via Zoom, I think the attorney may have to be present in person. I will say that for my cases, if my client was in custody, I did appear in person with them because I didn't feel that it was fair for them to have to appear in the department in person, and I just get to sit home or in my office and appear via Zoom.
And I can answer that question. Defense attorneys have the choice of appearing still in the jail courtroom with the defendants or appearing remotely with Zoom. If you appear via Zoom, basically you got to have the equipment necessary. And it seems that as a backup, the attorneys could actually call in if their machinery goes down or something. So, and it looks like they're trying to say log in now a little earlier before the courtroom starts for any hearings at 8:30, and that defendants will appear in the jail courtroom holding area and participate remotely using Zoom. Okay. So I guess they can actually come down and use Zoom.
No,
now.
that's the in custody. That
No, that looks like
doesn't quite because separately they define
out of custody. All right, may appear remotely if their attorney is also appearing. So we can. So it sounds like we can do what we were doing before. Still, you just didn't have. You don't have to go down there. I like to have them come to my office and then we Zoom together.
I've done that as well.
Yeah.
If the client is out of custody, I've had them show up at the office and Zoom right from here.
Right. It's just easier sometimes, than going all the way down to the court and then
only if they're in custody. If they're in custody, because they don't really have the option. They're stuck there.
True.
And that talking about people who are stuck in jail, that may bring us to the next topic, lawman.
Decision by our Supreme Court of California.
What do you have for us?
The procedure for bail setting in accordance with a case called Humphrey. Now, Humphrey was an older guy. I think it was 66 or something like that. But he had been arrested and put in jail. And he sat there for a whole year because he could not make bail until his case actually was being dealt with. And it turns out it's still not being dealt with. But they released him ultimately. And the big issue was, what do judges have to consider now when considering bail? It used to be that, and it was almost commonplace, that judges for the purpose of bail would be able to presume that the charges are true. Now, that is a presumption that has been attacked a lot by lawyers, and you should not let that presumption be there because I don't believe it's law. But it was just something that, for purposes of bail, I could assume that the charges are true.
Well, the court could assume.
The court could, yes.
Is Humphreys now saying that the court does not make that presumption?
Well,
or
it
is
doesn't
it saying
really
that there
address
are
it.
other factors
There are
that
other
the
factors.
court must consider?
And it's not, and it doesn't say that that's what the presumption is. So you should argue all the time that, hey, you can't presume that the charges are true.
And why should you be presuming that the charges are true if a person is considered innocent until proven guilty?
And that's true. And that's why it's kind of an anomaly where we're doing something that goes against one of the major tenets of criminal law and due process and everything, which is that you are presumed to be innocent no matter that they've arrested you, no matter what has been reported at all, no matter what witnesses say. You should be presumed to be innocent until and if found guilty. So Humphreys, though, stuck on talked about money bail, the need to have a money bail. So a money bail because we had a bail schedule prior to the pandemic, and then we had
Sacramento County, and each county could establish their own bail schedule.
Right.
Meaning they could set a specific amount of money that would be required to be paid, or a bond written in that amount before someone could be released from jail if they had been accused of a crime. And
it was set. Everyone would use the bail schedule as an example of based on your charges, an example of how much money that the bail can be set at. But what Humphreys talked about is that that practice of doing that is unconstitutional, and that a judge should now consider the individualized consideration of their ability to bail with money. So the pandemic came along, and right when the first Humphrey was coming out, right before it went for a second review to the Supreme Court. And so you didn't have to deal with Humphrey, but we had a schedule that said that pretty much non-serious and violent felonies, bail could be set at 0.
Now, to be clear, because have been misunderstandings. 0 bail is different than no bail. No bail means there is no amount of money that you or your family could pay to get you out of jail. That is what no bail means.
Right.
0 bail means the amount of bail is actually set at $0, meaning there will not be any money required for you to be released on those charges.
Right.
And what we saw during the pandemic, once the Supreme Court the California Supreme Court issued that order, is that people who were charged with low-level felonies,
Right.
their bail would be set at zero. Now, it's different if you are a person that is charged with a
Yes.
violent or serious felony, meaning a felony that is classified by what is traditionally called in California a strike crime.
Yes.
In those instances, your bail could be set higher.
In fact, if you had a strike as a prior at any time, the bail schedule was saying that your bail should be set at $500,000.
And that's if you had one.
One.
If you had two, the amount could be set at 1 million.
Yes, or no bail.
Yes.
Yeah. So,
and not very many people who are charged with crimes are going to have $1 million or 10% of $1 million that they can pay in order to get out of jail.
That's
or
true.
even that percentage of $500,000.
Right.
And so people would end up
Sitting there.
Yeah. waiting for the outcome of their cases in the judicial system.
In the pandemic, I mean, I saw people then in that same situation be able to bail because bail was radically less during the pandemic. They were also motions that were made to OR individuals, just get them out on their own recognizance. And what also was going on was people were able to mix. Well, you figure if you had to, if you were going to adhere to the regular bail schedule, bail, you can make motions and the bail would be lowered because of the pandemic, because of the inability to pay.
Not always would
Not
it
always.
be lower.
No, but I mean, but you can make the legitimate motion.
You can make the request.
Yes, to do so.
Mm-hmm.
And I think judges were more apt to abide and to comply because they did not want so many people still in jail. And we've learned that Zoom has become this great replacement for individuals showing up. I mean,
because if someone has to come to court and they can appear from the comfort of their own home or from their car or from their car or work, if they can find the one thing it's supposed to be a quiet place where you're not going to be disturbed.
Exactly.
Is what the court wants. They still want to maintain the decorum of the court and the professionalism of the court. So the request is that when you Zoom into court, that you do it from a place, if you're a client or someone charged with a crime, where you're not going to be disturbed. Lawman, I do see that we have a question in the chat from Protect and Provide. It says, how long does it take to become a judge? Also, have either of you thought about becoming one?
I'll let you
do
go
you want
first.
to take? Okay.
It's a short answer for me.
Lawman and I, Lawman was my mentor. We went through law school together, but Lawman is the one who ventured out first and put out his shingle to be out here and providing a service to the community in terms of having an African-American defense attorney out there willing to fight hard, to fight that hard fight and, win those cases that people will tell people that are unwinnable. And Lawman has done that. And he set the example for me. So I have not considered becoming a judge. That's not my path. I do hope that there are some people that we know, without naming names, that will become judges. And there are some others in the last few years that have gotten judgeships. So
absolutely,
that's not our path. Our path is trial litigators, right? This is what we do.
Exactly. And the truth is, I have never dreamed of being a judge. Never. I have been asked probably by 5 or 6 judges to try to do it, but I rejected each time, and here's why. I remember when Thurgood Marshall was put on the Supreme Court of the United States. He was put there at a time right after he won Brown versus Board, which was one of the amazing legal feats of our country. He was the head of the NAACP Legal Defense Fund. He was a mover and shaker in that particular organization and feared throughout the country as a litigator. Now, when Thurgood Marshall went to the Supreme Court of the United States, that was an anomaly. You usually don't go from an organization right to the Supreme Court. You start working your way up, federal court, federal courts of appeal, at least state court, something before you start rising up to the Supreme Court. But they put him from the ground to the top. And the problem was that all of the decisions would be 8-1. He'd be the one person dissenting all the time. He had no power. He could not now work with NAACP. He couldn't work with his people and things like that, because as a judge, it may be a conflict of interest to work with grassroots organizations and things like that. You just have to be careful because they could appear in your court. So I saw that happen. And what I saw was the NAACP Legal Defense Fund weakened. I saw that the battles subsided. It became quiet, and he became useless on the court, because how can you be the one in an 8-1 and feel like you're doing something? Because he wasn't. Technically, it was ineffective. And I call it, they cut off the head of the snake. The head of the snake was moving, doing litigation in the late 60s that was remarkable. And once that happened, things slowed down.
So do you think that they actually appointed him to the Supreme Court to prevent him from continuing on the path that he was going, arguing cases before the Supreme Court?
Yes, I do. I really think so. Because, because it happened. It happened. He became ineffective. I think Juan Williams wrote a book about his life, probably the latest person to do so. And they talked about how he would run the elevator. He would do things, little menial tasks, and people didn't know that he was a Supreme Court justice because he was so bored. There was nothing for him to do. And so I look at that and I go, if that happened to me, if you put me on the bench, I have to now be a judge and abide by things and make rulings that I don't want to make, that I could not make. I'm far more effective doing the trials that I do than I would be on the bench. Although people would argue otherwise, that, well, you've got more power, Keith. You can change things on the bench. No, you can't. No, you can't.
I don't know so much that you can change things, because you are limited in what you can do.
Right.
But certainly, I will say this, lawman, if you were on the bench and had the ability to make some of the sentencing decisions about the lives of young men that we see coming through this criminal justice system, I know that there would be more fairness in the system.
No, you know what would happen, Carm? In reality, you know what would happen. They're going to have me out in dependency court. They'll have me out in family law. They'll throw me in traffic court.
Give you an assignment where then you would not be able to be effective. Right. So to answer the question, there is no specific time period that it takes to become a judge. Sometimes whether or not you can become a judge depends on how politically connected you are. So there are all sorts of factors that affect that. There's no specific minimum age or that sort of thing. Right. So a lot of it can be who you are connected to.
And you got to get connected. If you're not connected in running for a judge, and you don't run meaning an election, but in putting your hat in for judge, if you're not connected, most likely you won't be selected. And you better be a Democrat or Republican, whoever is in office at that time, because they have a tendency to fill the slots with people of their kind politically. So it could take, I've seen a lot of judges. I've promoted individuals who are judges. I prefer to be behind the scenes because of my feelings about it. And I have seen people become a judge in 6 months' time. It doesn't take long at all. And what they're doing, though, is they're working they're working a little bit of everything. You want to bring something to the bench that other people may not have. So you should be a litigator. You should understand the law and the practice that you have. Litigation is far more important. I think number one, quality, because that's what you do. You're going to watch trials and referee trials for possibly the rest of your life. And if you don't understand the evidence code, if you don't understand what it's like to do jury trials, really heavy duty ones, then there's a disconnect between that judge and reality of trials. And I always call it, when we get new judges on the bench, is that the community has to train them. The community of lawyers have to train those judges in order to get them to at least get along with both sides, that being district attorneys and public defenders and private counsel. Now, look at Sheepdog said Kamala tried to pass a new anti-lynching law, and if it had passed, what would that law have changed? Well, I guess it's sort of like, how do you tell people to stop lynching people? You know, how do you tell them to do that?
Haven't we already said that when we said don't murder, don't kill?
Specifically, though, lynching is to deprive people of their chance in the criminal justice system, right? It's to take justice in, or at least what they see as justice, into their own hands and administer it by the lynching. So how do you tell people to stop doing that? Or will any law stop it? Very similar to the death penalty. They thought, well, if we kill people and show that killing people is wrong, and we will kill you to show that, people won't kill. Ineffective. This is why things are rolling back on the gun enhancements and things, because they thought these laws were going to stop people from using guns, and it hasn't. And now they're peeling back on those kinds of things. So you can have an anti-lynching law.
Well, go ahead.
Oh, but specifically, you're not, no one's going to say, you know what? I'm not going to murder him. I'm going to lynch him. See, so what's the difference? I mean, murder is murder.
I will say I didn't read the law that Sheepdog Protector is talking about, so I can't say specifically what would have happened had that law passed, because I didn't read the details of that. But as Lawman indicated, we have plenty of laws on the books, and it doesn't necessarily stop people from committing those violations. And just to be clear, regarding Lawman had said regarding gun enhancements, and we're talking about here in California, if you're accused of certain crimes, there are gun enhancements, and we've talked about that, that can be applied. When he says that's kind of rolling back, let's be clear. Penal Code 12022.53 is still strong and still in existence and still being applied to people who commit those crimes. And those high sentences are being imposed. The one difference is that SB 620 passed, I believe, became effective in January of 2018. And the one thing that did was it gave judges discretion to either strike the additional time that would be imposed for the enhancement, strike the enhancement itself, meaning not have the enhancement actually apply, or use a lesser gun enhancement, a gun enhancement that carried less time. So judges do have that discretion now. Doesn't mean they're necessarily going to exercise it. It will depend on the specific facts in the case before them.
These motions to come back pursuant to 620 are being heard all the time. And you would think it's very difficult if you did use a gun in a crime to now say you should strike the enhancement because I didn't use it, or, there's something going on. And I think where the attack is this. The attack is on the mitigation of it. Like, for example, if using the gun, I am trying to defend myself, and a jury saw differently, and either convicted me of murder, manslaughter, or whatever it was, but they also found the use of the gun. Coming back, you can present facts to show that, hey, this was really a tight self-defense issue. I mean, it wasn't, it's what we had available. It's what I had available for me at the time in order to try to defend myself, versus a knife or anything like that. So that may mitigate meaning an excuse or a justification for why I had to use a weapon, and that is in what I may think as self-defense.
Well, does everyone get to come back and have that issue?
I think if you petition, I think if you petition, I've been seeing a lot of people come back, and they're just coming back on remitters, meaning the
Well,
court has made a decision that
Was it
this should come back.
was it retroactive? I guess is my question. So if someone had been sentenced
Yes.
and their case was
Right.
final and their appeal was
Yes.
final,
I've seen those. Yes.
You have seen those coming back?
from before 2018, basically.
because if it's coming back on remitter, that's usually meaning that
Somebody had
they were
appealed or
it was the
something,
basis of an appeal.
Right.
Have you actually seen cases
Yes.
where their appeal was finalized,
Yep.
not related to that issue? They had appealed all of the issues that they could, and the court still allowing them to come back and address that issue?
I do believe so, just
Okay,
because of
I
the
have not
age of
seen that.
cases, you know.
I
So,
have
really?
not seen that.
Okay.
No.
It's now been after 2018 then? Or after
That's
it
my
became
understanding
effective?
is that their case had to at least that it could not be final.
Okay.
Um,
And that's hard to know because cases that came out in 2015 could still be on appeal in some
so
fashion
as long
and
as
stuff.
it's still on appeal,
It's
it's
not
not
closed.
considered final.
So it could be that wasn't retro. Now there is something new we talked about before that's coming through, 1509 AB, which is trying to change that same 10-20 life gun enhancement to, I believe, 1, 2, and 3 years. Now this is a situation which we'll probably be talking about this from now until forever, but it's a situation where our vote is going to be so important. There's a lot of legislation we don't like and we should vote it out, but there is some legislation that we should vote in. And this is one that people should focus on in trying to vote in. I mean, what it basically...
Well, right now, the AB 1509 has been offered as a bill by the legislature,
Right.
By I forget which specific assembly person offered it. So it's not something that is available for us as citizens to vote on. But what you can do is contact your assembly person, contact your state representative in the Senate, and let them know that you support this bill.
Right. And I don't know if it's going to go to the voters at all at any point.
I don't believe that it is. I think it's much like SB 620.
It's
it didn't go to the voters. It is argued by the legislature, presented in committee. They argue the cons and the pros of it, and then at some time it may be put up for a vote. But it's also possible that it could die in committee and never get a vote. And that is why, if you are in California, it is important for you to know who your state representatives are in the legislature here in the state capitol. Contact them. They represent you. Contact them and let them know that you support that legislation.
Yeah, really important. So
now go ahead.
Oh no, I was just going to go back to Humphrey's, the case about bail. Just going back to it, what it really means now is that the court, in making a bail determination, must undertake an individualized consideration of the relevant factors regarding their ability to pay, your ability to pay. And they might even have I think you can have hearings and stuff on your ability to pay and things like that. So that if, let's just say, okay, schedule's 150 grand, but I can only pay for a $25,000 bond. So now the court at least has to take in my ability to pay as part of one of several things that they can consider in order to reduce that bail to 25 grand or so. So it's a move forward. I tell you who it hurts is it hurts the bail industry pretty much.
Well, the bail industry has been making money off of
people,
poor people for a very, very long time.
That is true.
We understand their business, and I think that they will still be able to make money because there are still going to be people who are accused of crime
who have to bail.
Who have to bail out because of the fact that they have a prior record.
And also misdemeanor. I've seen a guy having to bail on a misdemeanor, $5,000, which, and during the pandemic, misdemeanors were supposed to be zero. Once again, zero bail. So, but he bailed out on $5,000, and now it could have been
It may
because
have been that he had failed to appear previously.
Oh no, it wasn't. This guy, he had no record, nothing at all. I think what happens is people go to jail and they kind of panic and say, "Get me out of here," and
they don't wait. To see what the bail setting is going to be.
Right. I mean, how many times have I seen individuals who bail out too quickly? And in fact, I'm glad we're on this issue because I had something come up, and I've got something that might come up that's similar to this. Two individuals, both actually the exact same crime, DUI allegedly causing injury. So felony DUIs, not because they had prior ones, but because felony DUIs, and alleged to have caused injuries. And the bail was set at $50,000. Now, we get to court, though. We can go to court 2 times, and it was never filed. The complaint was never filed. So at some point, they say, well, we're going to drop it, exonerate the bail. Now that
once
hurts.
The bail has been, once that percentage that you paid to the bondsman has been paid and you have been bailed out, the bondsman has done his job. Right. And so if they never file charges or don't file charges in the first few months or whatever, and then the bail is exonerated, but later they decide within the statutory time period that they are going to file and that you're going to be taken into custody and a new bail set, you would have to bail out a second time.
Now now this happened. And so what I was able to do was I monitored. It had to be 2 months, 2 or 3 months went by, even after we appeared the first couple of times, and months went by, and I just kept checking the index to see whether a complaint had been filed, which is the index is the public search index for the courts that will tell you whether a case is filed and what the court dates are. So I saw out of the blue one day, somebody had filed a complaint in this case, and they had not given him a court date. So what that meant was they issued an arrest warrant for the same crime he was already previously arrested for and then bailed out. And the way it worked is when I saw that filed, I then put the case on calendar. I asked to calendar the case because I'm concerned that the DAs have delayed, causing my client to have to re-bail again from the beginning.
But your client at this point, when you put it back on calendar, had not been rearrested. You put it on calendar.
I put it on calendar and brought him into the court because they said, well, you got to appear in person. And I understand that because what should have happened, or at least what was there, was a warrant for his arrest.
And so did the court recall that warrant because he was present?
They did recall it. However, what happened is he had to file what's called a reassumption. They charged him $200, the bailman, to do that. They reassumed that same bond.
The original bond.
Right.
But they did not have to do that. Sometimes the bondsmen are not required to reassume a bond. And so
the court requires it, yes.
The court requires that you either that they reassume it or you have to bond through through another agency.
Place. So
if you bond through another agency, you're paying that original whatever price. Negotiated fee all over again.
Now here's what happened. I peeked we're going to need a reassumption. I was like, clerk, hey, what do I need? We called up his bail bond. They sent it over by email. So we had the reassumption there, sent it to the court, filed it. And I was concerned that he had to go back in and be rebooked. And so we were trying, that was the problem, is that they said, well, we got to rebook him. So they took him into custody, and it took, I think we went in, 2 o'clock in the afternoon. He called me at 4 a.m. when he was released. Well, now the problem I was having was everyone was saying, wait a minute, he's already been booked. Pictures, everything is there. We filed the reassumption. Why does he have to be rebooked again?
And what were you told in regards
that? We just have to do that. And it'll only take an hour or so, you see, in and out.
Well, what I have discovered is that it depends on the county. There are some counties that can complete a booking process literally within a matter of 15 to 20 minutes.
Sure.
I'm not quite sure why in Sacramento County it takes so long to do a booking process, which basically consists of fingerprinting the person,
Taking a picture.
photographing the person, and running a records check to make sure that they are not wanted in any other
state.
counties or any other states or wanted federally.
Pre-trial
We
interview.
live in a day and age of uh, of technology. And so all of those things are very readily available. The sheriff can run a records check that lets them know whether somebody is wanted within a very short amount of time.
True.
So I'm not quite sure that there is a real explanation
No.
for why people are held for so long for a booking process, other than to inconvenience them.
My problem was we did this once. We went through the booking once. So I can understand if you did need, okay, we need another picture, we need another print, but it's the same crime. It's just now they're filing.
It's the same client.
Same client.
He hasn't
right.
changed his fingerprints or changed his face, has
so
he?
Why even having to go through that process again?
And you didn't get it sounds like you didn't get an answer that sufficiently satisfied you as to why that was required.
Exactly. Just that it'll only take a couple hours. That's it. So, and now wait, now here's the thing. I have another case. Like I said, I had two. So here comes the second case. And we appear, and the court says, well, it's not on calendar. Nobody's filed anything yet. So, okay, we're just going to take it off calendar. Now, that happened before the damage happened to the other client. I'm trying to remember, did the court exonerate the bail her? Because she billed on 50 grand. Mm-hmm. And it's the same crime. I mean, the same thing. No charges were filed. So in a month or two, when charges are filed, am I going to go through the same thing with her?
Have you found that out yet, or you're still in the waiting?
I'm trying to be proactive. I want to put it on calendar to take back the exoneration of the bail. And I want to start coming to calendar dates every month until and if they file.
I don't think that you can take back an exoneration. If you discover that it actually was exonerated, you can't, because now the exoneration relieves the bond company of the liability on the bail.
They have to reassume. That's why they have.
When you bail out, if you were to fail to appear for a court appearance, the bond company is then responsible for recovering you and bringing you back into court. When that bond gets exonerated by the court, the bond company is no longer liable to doing that.
And I want to nip it in the bud.
I want to ask you about Humphreys. Is the only thing that the court can consider is whether or not you can pay? Because what are some of the other factors?
Well, the factors are how do you protect the public or a victim in a case?
So could the judge deny someone's bail or set a higher bail based on the fact that they believe there are factors that support that the accused person is a danger to public safety or a danger to a specific victim?
Yes, they can. That is they did that before, and that is still alive. And what you will see if you actually stream and watch, you get to watch actually some interesting bail motions in that respect. The one department that they probably do the most in would be Department 60, domestic violence. You see some good arguments about whether or not a person has been harassing the other, whether or not they're following them around, and what are they doing, things like that. So and you hear the lawyers fighting for the clients, explaining that the person did not do anything. This is a dispute that has nothing to do with any violence involved, and trying to push away the fact that an individual's just saying that, hey, he's following me around, he's threatening to kill me, he's threatening to do this. So the judges can still think about the safety of the public and the safety of any particular person that's deemed to be a victim. All right, let's see what's there. Anything new there? Nope. Okay. So I mean, so Humphrey, that'll be something that your lawyer, if in fact that's necessary, could at least have an opportunity to say, well, Your Honor, bail at $50,000, that's nice. However, my client can only afford bail at $20,000. And the judge should take a moment in time and have a hearing to show that there is a compelling interest in lowering the bail in order to have the individual bail out. Now, where that's important is your job's on the line, things like that, society. I mean, you've got to do things with the kids. You're the babysitter. Whatever it is, you really need to get out. And so your ability to pay the bail is definitely now a major factor that can be considered.
Now, I'm just noting here that it indicates that the court is still to assume the truth of the criminal charges in making this assessment.
And what I'm saying is I've been watching arguments that that's not necessary or true, you see, although Humphrey didn't specifically come out and just say, hey, well, here's the law. They're just saying that it can still be considered. And so the argument by the lawyer is no, now that you're shifting it to the money amount, which Humphrey clearly says, you can, the truth of the charges is a sort of a bad presumption to take because it is against presumption of innocence. And of course, I mean, if that's the one thing that they lean on, if they just say, well, I can assume the charges are true, well, then nobody's going to bail, right?
Yeah. And judges, even if they believe that, aren't going to say that that's the only reason that they're holding your client in custody is because they believe that the charges are true.
Right.
They're going to point to public safety. Mm-hmm. They're going to point to perhaps your client's record, if they have a record.
Right.
Those sorts of things. They're going to look for whether or not there have been failures to appear on other matters.
Yes.
So if your client has had, even if it has been traffic, but they've had, 5 traffic cases where they failed to appear, those failures to appear may be used against them in determining whether or not they are someone who is likely to return to court appearances.
Right. And bail, realize, should only ensure that you show up to court. I mean, that's the real purpose of bail. Is to ensure that you will show up to court. You've got a stake in the matter,
But isn't it also to protect public safety? Isn't it a combination of those things? It's not all of those factors have to be considered.
Well, if we say that, then here's the argument. Look, you say that I'm a danger to the public or something like that, right? I mean, I'm a danger to someone. Unless you can show evidence beyond the crime itself that I am harassing or bothering a potential victim or witness or something like that, then I think that really lessens the blow on that because, it's hard to gauge behavior that someone is doing when nobody is witnessing it possibly. And just maybe the victim is saying, hey, somebody's calling me at night. I don't know who it is or, and stuff like that. So you get into these battles where I didn't do anything. Oh yeah, you did. You did it. I didn't do anything, and so and then where would the judge have to lie? You see, I mean, the judge has to fall in a specific slot.
I think that the judge is still going to look at the person's history.
Yes.
The specific allegations of what happened in this case, whether or not anyone actually suffered any physical injury, whether or not there's any relationship between the accused person and the victim such that the accused person might have a reason to have contact with them or know where they live. Those sorts of things, I think, are still going to have an effect. The prior criminal record of the person.
Yep.
Again, the probability that they're going to appear for the court appearances, whether or not they failed to appear in the past. It appears that those factors can still be assessed by the court.
True. And I'm not saying that they go away. It's just that now you get to add one on about whether or not they can actually afford the bail that you come to.
Yes.
You see.
And we have a comment in the chat from Warren Mack indicating that Khalif Browder spent 3 years in Rikers. Rikers is a prison in New York, accused of theft, couldn't afford to bail, and was innocent.
True.
And if that's the young man that I'm thinking about, I
Killed
want to
himself.
say that he was very young, and that
They threw him in.
Yeah, I want to say he was like 17 because I think in New
I
York
think he was under. Yeah.
they put children in jail with adults. And I think the things that he suffered in that prison caused him to have mental issues that resulted, I believe, in him taking his own life.
Exactly.
And no one should ever have to have that. Warren Mack has given us some additional information
16,
and said that the young man was only 16 at the time that occurred. And if I remembered, it was something regarding if he had taken a backpack or something. It turns out the backpack that he had was his own backpack. I don't know how someone and a child was allowed to languish in that system. I do know that New York is a big city. I do know that funding for public defender resources is probably lower than what it should be. And sometimes people are not going to get that individualized attention that they would get from a private attorney that they are paying. Now, I'm for sure not saying private attorneys are better because they're private, because I know plenty of public defenders who fight the good fight and who, if I were accused of a crime, I would want to have them representing me. One example I can think of, and he has passed on, but rest in peace, would be Tommy Clinkenbeard, who was one of my mentors, and he was a lifelong public defender. His son is now a public defender, but Tommy was someone that would fight the fight, and he was there for his clients, and he was a public defender. So we don't ascribe to what we sometimes hear where people say public defender, that's public pretender. No, it's the same as with any occupation. Some people are there because they believe in what they do and they're going to fight for you. And there are other people that are there to just collect a check. That applies in the private world as well. There are some private attorneys who are not going to fight for you and your rights. They're going to take your money, they're going to do the bare minimum, and then they're going to leave you by the wayside.
Right.
You're not going to get that from Carmen B, and you're not going to get that from Lawman.
So, well said, Carmen. I have nothing to say against that, you know. I mean, we see it all. We see things like that all the time. People even believe public defenders are not real lawyers. You know, I didn't have a lawyer. I had a public defender. And, you know, it's being prior public defenders. And when we were young, you know, we kind of understand how you can feel that way because you're getting paid out the county chest that's given to the DA.
You're not actually paying that person. And it's just coming from the budget for that office comes from the county, the same as any other county agency.
Right. But people believe that they're on the same team, see.
Well, I think that happens again when you have people who don't spend the amount of time that they need to spend with their clients. So if someone is not giving you the amount of time that you need to understand what's going on with your case, if you're going to feel like you are not getting good representation. Now, I, on many occasions, have to be the bearer of bad news. Meaning, and I'm sure Lawman, you as well, right? We review a case, we review the evidence, and it's horrible. And and by horrible meaning from a defense standpoint,
you're going to lose.
You're going to lose. They have you between a rock and a hard place.
You said you did it, you know.
And we have to, and the sentencing is harsh. And we have to tell you that, but you're going to have a full understanding of why. Right? We're going to explain to you what the evidence is. We're going to bring the videos in and show you. We're going to bring in the penal code so that you can see for yourself. And we're going to answer your questions so that you are fully informed in making the decision on do in your case.
Right. And that's the thing is that there's really the best course to probably give, and I would love to teach it, is is client control and how to get along with your client. There are individuals who just their style and the way they are in terms of personality
can be antagonistic
Yes.
to the client.
right, and you don't start off on the right foot, and so therefore, you don't now the client doesn't want to communicate with the lawyer. So the lawyer goes to court and they're standing there going, I don't know where he's been. I've tried to contact him and stuff. He just won't do this.
Basically, the relationship between the attorney and the client can break down.
Yes.
And you don't want that happening, because if that happens, the client's not going to trust the attorney. If they don't trust the attorney, they're not going to share the information with the attorney that may be essential to their defense.
Yeah. And so that's why I say that, how to get along with your lawyer, and there's some things you can do to make your lawyer work. What you've got to understand is you have a right to have your discovery, your paperwork redacted, but you also should have copies of the law, of what the elements are that need to be proved in your case for the charges.
And where would they get copies of the specific elements?
We talked about this. What was it, 2 shows ago or just last show?
I believe that we did.
Yes, that would be in the California Criminal Jury Instructions, known as CalCrim, CalCrimm. They are numbered from 100 to approximately 3,600. Now, that doesn't mean there are 3,600 instructions, but in that grouping of instructions are everything you would want to know about how to handle evidence at trial, how to prove cases, especially the elements of every charge, the enhancements and whatnot. So,
and perhaps what we can do for our next show is to actually talk about some of the jury instructions, so that we can provide that information, because a lot of times clients show up and they have no idea how the system works, how it's determined whether or not they are guilty of a particular crime, what specific factors and laws are applied,
what must be shown, and proved beyond a reasonable doubt.
We do have another question in the chat. Will bail bond system ever change? We were just discussing that, and it has changed. Because it used to, in California, there was no consideration for whether or not you could afford to pay. And now the law is a factor that must also be considered. There are also in other states that are where it is being addressed to try and not have cash bail be the main focus for whether or not someone should be in jail while their case is pending. We do also have another comment, and after I read this comment, I think we're going to have to bring it around to wrapping up. That comment by Mr. Mack is, Herbert Alford spent 5 years in prison for murder that a receipt from Hertz could have freed him, but it took Hertz 5 years to produce it. Yes, I did read about that particular case as well, that receipt showed, I believe, that he was at the Hertz counter renting a car at the time that murder occurred. And I believe as a result of that he may be actually civilly suing Hertz regarding that as well. When a client provides you with some information or with information that needs to be followed up on, that's one of the things that, as an attorney, your investigator has to do to try and basically, for lack of a better term, provide proof that the person is actually innocent. And I've had that happen a number of times. A number of times involved video, but sometimes if you don't get that video right away, that video could be gone. We are wrapping up. We're running up on the end of our time here this evening with Courtside. It seems as if it did. But as always, Lawman usually has something to address for us, or someone to discuss. And I'm noting that your mask says something in particular.
R.I.P. DMX. DMX died today. Very sad in that he struggled with drugs for years and years, and it seems like it's taken him. And whether you like the man or not, he was a force in the industry. When he was sober, he would do a lot of talks, and he was a very real individual. Things that had happened to him. He would explain how his addiction came from things that had happened to him, and his lifestyle, and the way he had to grow up and stuff. And he was always willing. Someone on the internet I saw just a minute ago was playing how when DMX first met Nipsey, and it was good. He was preaching to these boys and stuff. And that's one thing that you could guarantee is he was going to talk his talk, So, and he would try to help individuals in that way. So it's sad that he is gone. And I hope that, his soul rests and stuff, and that we remember him for the good things and stuff, that he may have brought. We all have our own green mile, I call it, to walk.
Or our own demons.
Right.
To fight that impact us. And
so, we can only respect how you deal with them. And if you are real about the way things happen. So I have no idea, how this all came up. I have no judgment on it whatsoever, except that we lost a life, and he brought a lot, to the table. So, we'll think of him today, we'll think of him tomorrow.
And so if you know someone that is suffering from addiction issues, try and get them to go to a program.
Right.
Try and get them help, because we don't want to lose people when we don't have to.
Right.
DMX, my understanding, was only 50 years old.
Yeah. 10 years younger than me. Yes.
Younger than me as well.
Yeah. And I'll tell you something about addiction and stuff. Look, it is a nasty animal, and people have to come to their own way of dealing with it. You can never tell someone, stop using drugs, stop that, cut it out. It ain't gonna work. They really have to come to it on their own. And so the approach sometimes is recognizing them and not judging right away what they're doing, but asking them to seek help from within, to come to a conclusion where they no longer want to play in that game. And because they have to come to it themselves before they change. That's something I just feel personally, I kind of know.
Well, it seems like America is becoming more treatment oriented for drug addiction issues than they were, say,
during the crack years,
marijuana
years.
They were criminals and locked them up.
Right.
Now that we're dealing with the opiate addiction and the opiates that were put out there and prescribed by the big
doctors,
pharma.
Yes.
Now
the real drug dealers have shown their face. Right.
Yes, the ones who are making billions and billions and billions.
In your doctor's office right now, selling that stuff. So, but that's another show.
Yes.
Let us know if you want us to talk about things.
Rest in peace, DMX.
Stop, drop. Shut them down. Send them shop.
All right. Thank you for spending your evening with us. And we'll see you again here next Friday, 6 p.m. at Courtside with Lawman
and Carmen B.